Hello, welcome to our classes. I am Dr. K.K. Misra. Through this video tutorial, today I will be talking about intellectual property rights. As we know that intellectual property rights had less importance somewhere in last of 80s or early 90s. It gained momentum and importance only after WTO, that is World Trade Organization, came into being on January 1st, 1995. As we know that World Trade Organization is a permanent body replaced by GATT, that is General Agreement on Tariff and Trade, which had very limited subjects included in it, like intellectual property rights were not one of the subjects included in GATT. Now let us concentrate on intellectual property rights here. It is really very important in today's time to understand what are intellectual property rights. Intellectual property rights actually refers to creations of the mind, inventions, literary and artistic works, and symbols, names, and images used in commerce. Intellectual property right is divided into basically two categories. One, industrial property right, and another one, copyrights. As earlier I indicated to you that these intellectual property rights, like subjects or things or even services, had hardly any importance before WTO came into being. But at the same time, these are making their great contributions to the GDP of any economy. This is why this recently has gained momentum and it has become one of the important subjects to understand, to study. Now, come to the two categories, industrial property right and copyright. Here, industrial property right includes patents for inventions, trademarks, and industrial designs and rather graphical identifications. Let me tell you that each of these, either patents, say for inventions, or even trademark, or industrial designs, etc., these have created, lot of importance for people to understand. As far as copyright is concerned, it covers literary works such as novels, poems, and plays, films, music, artistic works like drawings, paintings, photographs, sculptures, and architectural design. Rights related to copyright include those of performing artists in their performances, producers of phonograms in their recordings, and broadcasters in the radio and television programs. Now, here we will talk about intellectual property rights in more detail. Intellectual property rights are like any other property right. After all, why are we talking about the rights? Because these are very delicate subjects or the things. These are just unlike goods. The one who invents or the one who does anything on his own, he must be getting credit to that. The moment those new inventions come into practice, they may be pirated. The credit may be earned by somebody else. So this is why, so that the credit of such things remain with the original producer, or you can say original person who invented that. This is why we talk about the rights, and that's how this particular subject got its importance. So here, intellectual property rights are like any other property right. They allow creators or owners of patents, trademarks, or copyrighted works to benefit from their own work or investment in a creation. These rights are outlined in Article 27 of the Universal Declaration of Human Rights, which provides for the right to benefit from the protection of moral and material interests resulting from authorship of scientific, literary, and artistic productions. The importance of intellectual property rights was first recognized in the Paris Convention for the Protection of Industrial Property, 1883, and the Berne Convention of the Protection of Literary and Artistic Works, 1886. Both treaties are administered by the World Intellectual Property Organization. Yes, WIPO. One must understand what does WIPO stand for, because this term as acronym will appear many a times in my presentation through in fact in this video tutorial. So it is World Intellectual Property Right. Now, why promote and protect intellectual property? Let us try to understand it. There are several compelling reasons. First, the progress and well-being of humanity rests on its capacity to create and invent new works in the areas of technology and culture. Second, the legal protection of new creations encourages the commitment of additional resources for further innovation. Third, the promotion and protection of intellectual property spurs economic growth, creates new jobs and industries, and enhances the quality and enjoyment of life. An efficient and equitable intellectual property system can help all countries to realize intellectual property's potential as a catalyst for economic development and social and cultural well-being. The intellectual property system helps strike a balance between the interests of innovators and the public interest, providing an environment in which creativity and invention can flourish for the benefit of all. Now we will talk about normally how this patent or intellectual property rights as a whole benefit a person. How does the average person get benefited? Intellectual property rights reward creativity and human endeavor, which fuel the progress of humankind. Here are certain examples like the multi-billion-dollar film, recording, publishing, and software industries, which bring pleasure to millions of people worldwide, would not exist without the copyright protection. Without the rewards provided by the patent system, researchers and inventors would have little incentive to continue producing better and more efficient products for consumers. Consumers would have no means to confidently buy products or services without reliable international trademark protection and enforcement mechanisms to discourage counterfeiting and piracy. Now we will try to understand what is a patent. A patent is an exclusive right granted for an invention, a product or process that provides a new way of doing something, or that offers a new technological solution to a problem. A patent provides patent owners with protection for their inventions. Protection is granted for a limited period, generally 20 years. Now, why are patents necessary? Patents provide incentives to individuals by recognizing their creativity and offering the possibility of material reward for their marketable inventions. These incentives encourage innovation, which in turn enhances the quality of human life. What kind of protection do patents offer? Yes, it is very important to understand. Patent protection means an invention cannot be commercially made, used, distributed, or sold without the patent owner's consent. Patent rights are usually enforced in courts that in most systems hold the authority to stop patent infringement. Conversely, a court can also declare a patent invalid upon a successful challenge by a third party. What rights do patent owners have? Yes, a patent owner has the right to decide who may or may not use the patented invention for the period during which it is protected. Patent owners may give permission to or license other parties to use their inventions on mutually agreed terms. Owners may also sell their invention rights to someone else who then becomes the new owner of the patent. Once a patent expires, protection ends and the invention enters the public domain. This is also known as becoming of patent, meaning the owner no longer holds exclusive rights to the invention and it becomes available for commercial exploitation by others. Now, what role do patents play in everyday life? Patented inventions actually have pervaded every aspect of human life, from electric lighting, patents held by Edison and Swan, and swing machines, patents held by Haw and Singer, to magnetic resonance imaging (MRI), patents held by the Median, and iPhone, patents held by Apple. In turn, for patent protection, all patent owners are obliged to publicly disclose information on their inventions in order to enrich the total body of technical knowledge in the world. This ever-increasing body of public knowledge promotes further creativity and innovation. Patents, therefore, provide not only protection for their owners but also valuable information and inspiration for future generations of researchers and inventors. Now, how is a patent granted? The first step in securing a patent is to file a patent application. The application generally contains the title of the invention as well as an indication of its technical field. It must include the background and the description of the invention in clear language and enough detail that an individual with an average understanding of the field could use or reproduce the invention. Such descriptions are usually accompanied by visual materials like drawings, plans, and diagrams that describe the invention in greater detail. The application also contains various claims, that is, information to help determine the extent of protection to be granted by the patent. Now, what kinds of inventions can be protected? An invention must, in general, fulfill the following conditions to be protected by a patent. It must be of practical use. It must show an element of novelty, meaning some new characteristic that is not part of the body of existing knowledge in its particular technical field. That body of existing knowledge is called prior art. The invention must show an inventive step that could not be deduced by a person with average knowledge of the technical field. Its subject matter must be accepted as patentable under law. In many countries, scientific theories, mathematical methods, plant or animal varieties, discoveries or natural substances, commercial methods or methods of medical treatment, as opposed to medical products, are not generally patentable. Another question is, who grants patents? Patents are granted by national patent offices or by regional offices that carry out examination work for a group of countries. For example, European Patent Office (EPO) and the African Intellectual Property Organization (OAPI). Under such regional systems, an applicant requests protection for an invention in one or more countries, and each country decides whether to offer patent protection within its borders. Now, WIPO, Administered Patent Corporation Treaty (PCT), provides for the filing of a single international patent application that has the same effect as national applications filed in the designated countries. An applicant seeking protection may file one application and request protection in as many signatory states as needed. So this was all about this video tutorial wherein I discussed about intellectual property rights, its importance and the different aspects of patents. I hope that you have understood it and liked it. And if you have liked it, please do not forget to subscribe my YouTube channel R Classes and press the bell button and pass it on to others, those who are needy now and in the future. Thank you. Please like, share and subscribe. Thank you very much. Have a nice time. Best of luck.